Let's jump right to David Katz because there's so much to talk about. Of course, David Katz, a former federal prosecutor, now a defense attorney in the Los Angeles area, and always so full of so much knowledge. Please welcome the amazing David Katz to the Mark Thompson Show.
Great to be with you, Kim.
Hi, I like your blue shirt today. You're looking really snazzy.
Well, not only that, but you can imagine in my life, I've gotten all kinds of gifts with cats on it. Well, this is a tie with some black cats on a beach. Can you see it? On
it's
beach
cute.
chairs.
Black that's adorable.
Beach chairs.
Love
and
it.
I thought I'd wear it for you. I was hoping you could play the Year of the Cat like we used to on Pat Thurston's show, but maybe if you can gear that one up, because it's been a great year. I guess 2 more Mark Thompson shows after today for me, but it's just been a great year with you and Mark and your whole staff.
Well, it's been a great year with you. Happy Hanukkah, happy holidays to you. And thank you for all your contributions to the show through the year. You're amazing. And we've lucked out because if we're talking about legal things to talk about, we hit the jackpot with it today. Let's start with a judge pausing the Trump trial, if we could. And I would, by the way, I would play that song for you, but I think it's a copyright protection. So I'll have Albert look into it and see if we can't pull it out.
By the way, Pat also loved What's New Pussycat, and she always pointed out that my adversaries did not see me as a pussycat in court, but she loved to play that old Tom Jones song.
I like my favorite one was the Everybody Wants to Be a Cat. That one. And everybody does want to be a Katz in the Katz office. So Trump's election case court, the DC court, I guess the judge has paused everything, waiting now to see if this presidential immunity defense will stick. And because she's paused everything, I guess my concern is this another delay? Is this playing right into the Trump defense hands, or is this what she just had to do?
She basically had to do this. She did not pause some of the ongoing rulings in the case. So he's still under his bail conditions. He's still under the gag order, which was only slightly curtailed, but basically affirmed by the DC Circuit Court of Appeals. He's also under these discovery rulings that he's not to share the discovery with anybody outside of the defense team. So that's still in place. But the problem is that his lawyers picked these 2 issues, which I believe don't have any merit at all. But they picked 2 issues that are kind of issues of first impression, because after all, we haven't had a former president indicted before. So of course, the issues about this are going to be ones of first impression. I see them both as baseless. One of them is this argument on the merits that there is presidential immunity, which means for a former president, because remember, there were all those arguments that you couldn't indict a sitting president. Now Trump's team has come up with these arguments that, oh, by the way, you can't indict a former president. Now, taken full bore the way that they do, this would actually mean, if there were such a thing, that Biden could go kill Trump, right? And then he'd have presidential immunity. He couldn't be charged for it while he was the president, and Biden couldn't be charged for it after the president. So that is obviously absurd, and a lot of the commentaries have been on that topic. He's going to ultimately argue, if he hasn't already, Trump, that it's for the course and scope of the duties, and that the indictments and the 3 conspiracies were sort of in the course and scope of his duties. I don't think so. I don't think any court is going to think so, and I don't think the Supreme Court's going to think so, Kim. But the argument goes that what he did with the slates, to have an alternate slate, it was one of his duties to protect the elections, and he was protecting the integrity of the election, Trump is going to say, and that was in the course and scope. So it's not as though a president went and shot somebody. That's obviously not within the course and scope of this so-called presidential immunity for former presidents. But it would be that it was somehow within the course and scope. The other things, remember, that argument was actually made slightly different setting, but it was made and is still hanging around in the 11th Circuit Court of Appeals from what's his name, Mark Meadows, who was the chief. The chief of staff to the president. He was Trump's last one. He's the one who says everything I did in Georgia when I went down there and I wanted to monitor the vote, all of that was within the course and scope of my authority, and therefore I should be tried in federal court. The district judge said, no, that's still hanging around in the Court of Appeals down there. This would be sort of a similar argument on this. that the presidential immunity is for things that are within the course and scope. I don't think that one's going to win. But the problem is that it's one of those that gets an interlocutory appeal. It's not what we call a writ of mandate, which is an extraordinary remedy. That's not an appeal. An interlocutory appeal is a true appeal. And on this basis, they can appeal. And on what they claim is double jeopardy, also, in my view, almost frivolous. This is the one that, because he was tried in the Senate on impeachment charges from the House regarding the January 6th insurrection, that he has somehow faced the charges already. He's already faced jeopardy. Well, he hasn't faced jeopardy because he couldn't go to jail in that case. That wasn't a criminal case at all. So the idea that you've been charged in an administrative case, an impeachment case, a civil case, and that somehow gives you a right not to be charged because you've been placed in jeopardy already. It's just common sense. He was not placed in criminal jeopardy in that impeachment proceeding. He could have been removed as president. He could have been not allowed to ever run again. Remember, that was one of their possible remedies. The Senate ended up not finding him guilty, but it's guilty, again, in that impeachment sense. It wasn't guilty in a criminal sense. I guess a better way to say it was he would have been removable. Having said all that, he does have these two issues that I believe are baseless, which he can appeal. And once a case is under appeal, then this is the idea that it divests the trial court of jurisdiction. Let's assume for a second he absolutely has a right. I don't think the Supreme Court's going to say so at all. I think they're going to say quickly, no, he doesn't have such a right. But let's assume he has a right as a former president not to be proceeded against at all. Well, he's being proceeded against in the interim while the Court of Appeals and the Supreme Court are trying to figure that out. Now, in terms of the timing, Kim, here's what I think is very important. The DC Circuit has agreed to expedite it greatly. They're going to have all the briefs filed by January 2nd or 3rd. All the briefs filed. That means that the Court of Appeals in DC could rule on this issue by the 4th, 5th, by the middle of January. Given that, the U.S. Supreme Court may say, you know what? Let's let it go through the circuit court as it normally does because it's going through so fast. And then we can always grant certiorari back in the middle of January. We can take it in January. We can put it on a very expedited schedule. People will recall that U.S. v. Nixon was decided in, I think, 16 days by the U.S. Supreme Court, 8-0 against then President Nixon. So the argument is you could do the same thing here. You could take it in the middle of January. So I think there's two alternatives. The Supreme Court will sit back once they get Trump's opposition, and they'll say, you know what, the DC Circuit is deciding this so fast, it's not going to be a delay. Or they may just say this is such an important issue. The famous steel mills seizure by President Truman was one where they went right past the Court of Appeals. They went straight to the Supreme Court. We have had in our history these major important cases that have gone straight to the Supreme Court. One way or the other, I don't think this one's going to end up delaying the trial. Of course, the two disastrous scenarios, the most disastrous is that 5 justices on the Supreme Court could say there is such a thing as presidential immunity. That would knock out this case. I don't think that disaster is going to happen. The lesser disaster is that the Supreme Court just sits, cogitates, can't make up its mind, and that would, of course, delay the trial April, May, June, and pretty soon there's not a trial in this case that goes to a jury verdict before the election in 2024. Long answer.
No. And how much faith do we have in the Supreme Court? I was reading an article that Clarence Thomas is being pressured to recuse himself from this Trump immunity case by Senate Democrats. They're saying, Clarence Thomas, you need to recuse yourself from deciding whether Trump has immunity from prosecution for alleged crimes committed while president. They're saying Thomas poses a potential conflict of interest because of his wife, Ginny Thomas, who has previously supported Trump's false claims that the election was stolen. She gave testimony during the January 6th, the hearings, the committee investigating hearings, that she still believes that the election was stolen from Trump. So I don't know if you can have Clarence Thomas recuse himself because something his wacky wife believes or not, but he's facing this pressure. I don't see him stepping down. Do we trust the Supreme Court not to try to delay and kind of roll this out so that it goes past the election cycle?
I think on this one, I have confidence in the U.S. Supreme Court. You know, after Dobbs reversing Roe v. Wade, and after some of their very pro-business, anti-union rulings, you can certainly say this is the most conservative court in 100 years. This is the most conservative court since the one that FDR had to deal with at the beginning of his time in office under the Great Depression. But I think on certain issues like this, I think number one, they won't want to be seen as three lackeys, picked by Trump along with two arch conservatives. They just don't want to be seen that way. I think Barrett and Kavanaugh are good on this one. I think Gorsuch may be good on these issues because he's kind of a process guy. Very conservative. I disagree with him often. But I think on all of these issues, they'll say, this cannot be right. A former president cannot have immunity. Look at it. Former senators don't have immunity from prosecution. Former governors don't. Where is the basis in any statute or in the Constitution itself for this so-called presidential immunity? And as I say, the double jeopardy claim, he's never gone through criminal jeopardy, having gone through a Senate trial. Whether he got acquitted or convicted there, acquitted and convicted mean utterly different things. And so I think we're going to be okay on this one. I'm getting to be more optimistic that this trial could actually start in March or April. Now, one thing she can't do is she can't pick a jury or do those kinds of things. And there are some other motions that are kicking around. So if this case comes back from the Supreme Court, as I expect it will, saying both of those arguments fail and that, let's get back in the saddle, it will take a little longer to get back in the saddle because there'll be some motions that have been stayed during this period of time. The defense attorneys will say, oh, my goodness, we have all these great ideas. We have all these great motions. She'll say you should have brought your motions before. But she can't start picking the jury until this matter is returned to her, until she's until this divestment of jurisdiction, such as it was, the jurisdiction has to be returned to her to at least start jury selection. And that she can't do unless it comes back. Will it come back in time for the March 4th trial to go? If it goes in April, it's about the same thing. But if it gets kicked much later than that, huge mess.
Well, this election interference case in Washington, D.C. is not the only place that Trump's lawyers are trying to say immunity, right? So they tried to say he had immunity in the E. Jean Carroll case. And apparently that's the appeal, is that, I can't be found liable for this. I have presidential immunity. You can't do this to me. Well, an appeals court is telling Trump, no, you can't assert presidential immunity in a defamation lawsuit, but the one brought by E. Jean Carroll, saying he waited 3 years too long to invoke that as a defense. This is the second U.S. Circuit Court of Appeals in Manhattan. They uphold a federal judge's same ruling in June, saying a 3-year delay is more than enough under our precedents to qualify as undue. We say presidential immunity is waivable, and the defendant waived his defense.
Well, that's normal. You have to bring all of your motions timely in the trial court. And he didn't bring this 3 years ago. And so that you have a brainstorm on appeal, they don't want to hear about your brainstorms on appeal. They want to hear about motions that you've made in the trial court that were properly briefed and argued and that were lost, and then they're preserved for appeal. A motion you don't make at all in the trial court is not preserved for appeal because you didn't make it in the trial court. This is the same thing, by the way. Trump's always screaming, "Where's my jury?" in that civil fraud trial.
It was his defense attorneys that are to blame for that, right?
It's arguable whether he would have gotten a jury or not. That would have been a tough question, but it's a very easy question if you don't ask at all. The judge never had to decide it because Trump's own lawyers didn't ask for a jury. So I'm not surprised at that one. But since we're playing the lightning round, Kim, what else do your viewers and listeners want to know about?
Well, let's talk about what happened with the Supreme Court deciding to now hear this case on mifepristone, the abortion pill, right? They say they're going to rule on limits on this medication, and they didn't take a previous case regarding the abortion pill, but they're taking this one. And now, after the dismissal of Roe v. Wade, anytime this court wants to weigh in on what I can and can't do with my body, it makes me all kinds of nervous and angry. What are they doing? What's the thought on this?
I don't blame you. It makes men nervous and angry too, because we love women, we care about women, and these are problems for everybody. Right. But I understand the particular way it must be annoying to you and to other women. This is actually good news. The people who say, I love to watch you, Katz, but you depress me because you try to accurately predict what these courts are going to do. And sometimes it's a bitter pill. I think this case will not be a bitter pill. because this is the abortion pill, and the Supreme Court had a chance to affirm. They shopped all over the nation. They found this, Christian warrior district judge down in Amarillo, Texas. He issued this decision. They went to him. Then they went from there to the Fifth Circuit, the most conservative circuit in the country. And they ended up with these rulings that affected blue states. People who say, well, I feel terrible for, my sisters in the red states, but at least this is not affecting me here in the blue state. Yes, it would if they went the way that cherry-picked trial judge down in Texas went and the way the Fifth Circuit went. But the Supreme Court did not affirm those injunctions. The Supreme Court dissolved those injunctions. And I think the Supreme Court took this case now to make it very clear that you cannot go back and challenge these FDA decisions and get them thrown out. We talked about whether the U.S. Supreme Court, Mark and I talked about the fact whether on this case, the U.S. Supreme Court would go with big pharma or big right-wing anti-choice conservatives. And they are going to go with big pharma because big pharma invests money not only in this abortion pill, but they invest billions of dollars in cancer drugs. They invested billions of dollars in the COVID drugs, vaccines, all this kind of stuff. And if you can go cherry pick one judge in the country and have that judge issue a nationwide injunction against the sale of your pill after you've spent billions of dollars to develop it, this does not make any sense. The FDA has to be given more respect than this. The FDA had proper proceedings. They haven't challenged the FDA proceedings for a long, long time. That's why the initial authorization is okay. It's properly authorized. They can't go back and challenge that from, I believe, 2000. What they're trying to challenge now, the anti-choice, right-wing radicals, is that the certain things in the later FDA approval, like telemedicine, like not having to visit a physician in order to get the prescription filled, like the use of the mails, that should fall. So you would still be able to get the pill in either a red state or a blue state, but you would have to go to see a doctor, which would be a big hassle. And in some places, the doctors won't help you. In some places, it's a long drive to the doctor. You couldn't do it by telemedicine. Maybe they couldn't mail it to you. So you'd have to go in and get it. More of a hassle, more of a restriction on a woman's right to choose. But I don't think the Supreme Court's going to go for any of that. I think they're going to make it clear that this process was flawed, this litigation process, and you cannot go back and challenge these FDA decisions by running to some handpicked trial judge around the country. So I think this one's going to come out okay for women and for blue states and for the country.
Well, I love your optimism on this one, but I look at a Kavanaugh and an Amy Coney Barrett and these people that are staunchly, they during their interview for the job, they said, well, it's law, I'll support the law. And then they come in and they take away Roe v. Wade and a woman's right to choose. And so now I don't have faith in that their religious fervor isn't affecting their decisions like this.
If you're a cynic, they're going to go with big pharma. Kavanaugh and Barrett love big pharma. Those conservatives on the U.S. Supreme Court love big pharma. They're going to go with big pharma. And this is a big pharma issue because this pill is very safe and effective. It also makes a huge amount of money for the manufacturers. They put a lot of money into developing it. And really and truly, I mean, these are other drugs too. And so Kavanaugh and Barrett will think about the fact these are COVID vaccinations. These are cancer drugs. All of these things could be challenged by someone who doesn't like them. And if you could get this kind of injunction, I think they'll certainly say that these nationwide injunctions should be very, very carefully thought through before these district judges issue nationwide injunctions. Okay, what's next?
Can we talk impeachment? Because yesterday there was a vote to move forward with the impeachment inquiry against Joe Biden. And here's my thing. And I know this isn't legal, and I know this isn't the way things are done. But I think there should be some type of baseline information that qualifies you to move forward with an impeachment inquiry. That you should at least have to have a certain minimum level of evidence in order to move forward with something, in order to make it not be this wholly political thing. That's not the way it is. But here we go with an impeachment inquiry. And, I don't know.
I'm looking at, go ahead.
No, you.
I'm looking after you. I'm looking at the bright side of things today, not just because I'm in a good holiday mood, but also I think that a Congress that wants to slit its own throat can do it, and the Republicans are doing that. We have a Congress member named Garcia, who's in a district out here in Southern California that Biden won. We have, I think her name is Young Kim, out here. She's a Republican in a Biden voting district. There's still a third one out here. They may have all lost their seat. They've already started running ads against them. What's wrong with you people having an impeachment inquiry with no evidence against the president? So I think that they have now the super right wingers, the Gateses of this world, this new guy Johnson, who's the speaker. They have really thrown their moderate members under the bus because they have to own this now. Every single one of the Republicans, if you have a Republican Congress member here or anywhere in the country, remember your Congress member voted for this. It's just evidenceless impeachment. And, they should be doing things like, helping Ukraine, dealing with this crisis in the Middle East, doing something about the border. These are all the economy, inflation, high interest rates. Why isn't your Congress member doing something about this? Meanwhile, they're running down this rabbit hole. So I think that, like I said, if you want to cut your own throat, and at the end of the day, the impeachment inquiry is not going anywhere. And so, if you want to look stupid, I guess you can make your whole party look stupid. And so I think that they all have their stupid hats on with this vote, every one of them.
They're stupid hats. Yesterday, Hunter Biden also said, listen, I'm not going to comply with this GOP subpoena because he wants to testify in a public fashion, not behind closed doors, where his words can then be manipulated after the fact, when the press conferences happen and the Republicans are asked, well, what did Hunter Biden say? They could say anything because his words were not heard by the public. And he says he doesn't want to do that. I'm wondering, could he really face contempt of Congress charges for denying their subpoena, if they're going to keep it a private closed hearing? And what does that mean when you face contempt of Congress charges? Does anything happen to you?
You could either be held in civil contempt, potentially, or criminal contempt. And I've been very astonished by how Hunter Biden and his attorneys have handled this case, starting with turning down the misdemeanor disposition in the Delaware federal court. And then when it blew up in court, not immediately saying, well, we didn't want to have these kind of problems, so rewrite it, Mr. Government Attorney, and where do we sign? Because we want the misdemeanor. And of course, that's blown up in his face right now. I mean, I think they're really ruining the day that they let the thing blow up in court, that they didn't draft it better. I know that there were some legal issues that were raised about it. We spent a session, you, me, and Mark, on it at the time. I think it was in about June of this year. He had what they called a sweetheart deal. These cases don't end in misdemeanors. They were going to investigate how this one ended in a misdemeanor. It was for these same years that he just got charged with felonies for, and where he's facing prison time. And Pat Thurston and I talked about this on her radio show on a Friday night, and we depressed everyone in the Bay Area because it's depressing how I think Hunter Biden kind of misplayed his cards. And I don't think that Abby Lowell, who's a very renowned lawyer, misplayed the cards so much as I think. I'm totally speculating because I've had, I've dealt with a lot of criminal defendants, both as a federal prosecutor and now as a criminal defense attorney. And there are some who just don't get it. And I think Hunter may have been one of those guys who just didn't get it. He said, I'm not signing even misdemeanors. I want this, I want that. And I think that Hunter, I'm speculating, may have just asked for too much. It's kind of blown up in his face. So turning to the press conference yesterday in front of the Capitol, great optics. But you wonder why he didn't have that press conference at 9 o'clock in the morning, and then at 9:30 walk into that congressional hearing room and assert his rights under the Fifth Amendment, which is what I believe he's going to do when they have the open session. And so why create even more? He could have had all the drama, Kim, all the optics, and then he could have gone in there and asserted his rights under the Fifth Amendment, because you hear on right-wing media that, oh, maybe the indictment of him where he's facing years in prison, maybe that's all part of an elaborate cover-up. It's not an elaborate cover. He could have taken his rights, asserted his rights under the Fifth Amendment before he was ever charged. Now that he has been charged, if he's charged with misdemeanors, if he's charged with felonies, he should assert his rights under the Fifth Amendment. And no one's going to convince me that when the push comes to shove and he actually does appear and he raises his right hand, that he's not going to say, as to all this stuff, I assert my rights under the Fifth Amendment. Then he can go out and say it's a witch hunt and everything else. And I think it's much more of a witch hunt with him than it ever was with Trump. So anyway, that's my feeling about that, that he's doing these kinds of things, and his dad, the president, taking him to this big bash, having him, at the White House. I think it was a state dinner for maybe the Indian prime minister or for somebody. I don't know. That just seemed to me, now the president's defense is that it's better love your son too much than to love him too little. And I just think that they have, the Republicans have tried so hard to make something of this, and I think they have really not had much rope. But I think that the president and his son have given the Republicans a little bit of rope, and I kind of wonder at the strategy that they're pursuing right now. I looked up the issue because I knew you were going to ask me about this closed hearing. It's also called executive session or closed hearing.
Right.
And as best I could tell under the law, the House has a right to pick whether it's a public session or it's an executive closed session. And I understand what his argument's going to be. If he does get indicted for this or charged with this as a crime, then they'd have to get Merrick Garland's Justice Department to charge. But let's assume that happened and he was charged with a crime. You remember there were a couple of people who were charged with crimes. I think Bannon and another one who refused to show up for congressional subpoenas to testify. Right. And they were charged, and I think Bannon was found guilty. I think the other one might have been found guilty. I don't want to say his name in case I'm wrong. But let's assume that he were charged. He's going to make the argument that you guys leak like sieves. It was all going to get leaked. The reality is it gets leaked. I wanted a public hearing with a public record. But, even in an executive session, there's a transcript. And so there's a record of what actually happened. Now, his argument is going to be that, well, wait a second, how it really works is they leak the part that hurts me. I can't get the part out of seal or out of the executive session that helps me. And it's very unfair. And whether he made a good record, if he made a record once he got the subpoena and it was to executive session, that, look, I will appear in a public hearing, but I will not appear there. Here are all my reasons why I will not appear in your executive session. Don't have an executive session, blah, blah, blah. Did he make such a good record? And that we don't know right now. He's got good lawyers, so maybe he made an excellent record, and maybe he's looking forward to challenging the criminal case. But it just seems to me like another potential criminal case against him that he could have avoided by simply showing up and taking the Fifth. What are they going to say that he said in closed session? What are they going to leak? He's going to take the Fifth as to every single question. What are they going to leak that's going to hurt him?
Nothing. Yeah. I know we're running out of time, but I wanted to throw this one last issue at you because it was kind of flabbergasting to me. This is about Rudy Giuliani. And Rudy, who's involved in this case where he allegedly defamed two poll workers, a mother and a daughter, who then faced all kinds of threats and things to them, happened to them. He was supposed to testify in the closing waning moments of this trial and didn't. But I think it was yesterday, came outside, if not yesterday, the day before. My days are blend together now. But a couple of days ago or yesterday, he came outside the courthouse and reiterated all of the things that he said about these two women that landed him in this defamation case in the very beginning.
Giuliani was playing a very, very weak hand after all the things that he's like Trump in the sense that they complain about the legal system after having made their own legal problems by their own misconduct, by their own misdeeds. And then they complain, oh my God, the system's so unfair to me. It's like, you did it, own it. And it's very hard for him to own it. It's a civil case, but he's facing tens of millions of dollars. And that's without punitive damages. These women have suffered tremendously. They suffered at the hands of what Giuliani sent out. These people who have these huge Twitter followings or X followings, whatever they're called now, they can do great harm. And they can really terrify people because you think this went to millions of people and they're sending me things that they want to lynch me. And, it's anonymous. So anonymous people are sending me messages that they want to lynch me. I better not go home. The FBI told one of these ladies, or maybe both of them, not to go home, that they couldn't even protect them. I guess, and I don't know if they want to put in any kind of witness protection thing. So they're paying out of pocket. Anyway, they have a great claim for all these damages. And Giuliani didn't take the stand today. I imagine just because he's so annoying, and the jury is so, turned against him because of the evidence against him, that he figured he would make a terrible impression. He didn't have to testify. No one has to testify. He had to agree to a deposition. And apparently he kept playing around with the deposition. He didn't turn over the documents he was supposed to. Finally, the district judge was going to sanction him and do all these kind of things. And he finally said, well, I agree that what I said against these ladies, that they were lies. So he went out on the courthouse steps and said, well, they really weren't lies. And then the judge admonished him and said, you basically just defamed these women again.
Right.
Apparently there wasn't a gag order, so he's not in contempt of court because he didn't violate a gag order. We may yet hear that there was a gag order that he violated, but I think right now he didn't violate a gag order. So like I said, he was playing a very weak hand. And so I think that he wanted to send out that message in the hope that he would taint the jury pool in the same way that Trump hopes to taint the jury pool by getting these things out in the media and hoping that some juror hears them. So I think that Giuliani thought that I once had a higher opinion of Giuliani, like a lot of the country did. But I think that what Giuliani was all about was to get his message out that he's broke. If you get on the stand and say you're broke, they can ask you on cross-examination. Well, wait a second. The whole world thinks you only own one condominium. Don't you own this? Don't you own the other thing, right? They could actually cross-examine him if he took the stand. So he put out the story that they weren't lies after all, although he basically admitted in court that they were lies to stop the discovery process from going forward. So after he said that they were lies in court to resolve the matter, then he runs out, right? And he tells a reporter in front of the courthouse, knowing it's going to be widely covered, well, they weren't really lies. I really did think that something untoward was going on, for which he had no evidence against these ladies. That's how he defamed them again. And then he had people, himself or his flacks, put out the story that he's so poor, he really can't pay a judgment. It's going to be the end of Giuliani. Well, you do something terrible like that, and you get hit not only for the compensatory damages, but potentially for punitive damages. He's in Washington, D.C. in federal court. He has 8 jurors because it's a civil case. We'll see what happens. I think they just made the closing arguments already.
Yeah, I'm looking forward to it. David Katz, this time has whipped by with you. Thank you for being here. Have a wonderful holiday season. I'll hope to see you next week.
Oh, it's so great to see you, and I will be with you next week. I can't wait.
Yay.
Really a pleasure, Tim. Really a
pleasure to be with you. Bye, David Katz. Bye.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.